deal with the matter of the King on the application of medical justice versus Secretary of State for the Home.
Good morning, my lord.
Yes, Mr. Penn.
I appear on behalf of the Secretary of State, together with Miss Julie Anderson. My learned friend, Mr. McCullough KC, appears on behalf of the Respondent, Medical Justice, together with Miss Shushin Liu and Miss Laura Profuma. This is the Secretary of State's appeal against the order made by Mr. Justice Linden, in which it was declared that the second opinion policy was unlawful and that the Secretary had acted unlawfully by failing to consult medical justice in relation to the, I'm going to call it the SOP, the second opinion policy,
Okay.
the SOP, in breach of the latter's legitimate expectation to be consulted. Subject to the court's views, I propose to deal with the matters in this order. First, I'd like to provide a short overview of the litigation, just to provide context as to why and the issues really in the case. The second is to propose to take the court to the three different guidances which are referred to and which form the basis of the judgment. Third, I'm going to deal with the arguments as to why the Secretary of State says the court's finding, substantive finding in relation to why the SOP, the SOP, is substantively unlawful. Then I propose, fourth, to deal with the evidence relating to consultation or engagement. And fifth, I propose to deal with the reasons why we say the court's assessment of legitimate expectation was flawed. And lastly, insofar as the court wishes me to, I would deal with the issue of whether the appeal is academic on ground one.
No particular problem with that. We had already reached the provisional view that we would not decide the question of whether it's academic in advance. We will consider it in the context of the substantive arguments, which on ground one, it really only affects ground one. We will hear Dimeni essay. Mr. McCullough, you don't wish to object to that, do you?
My lord, not at all. And indeed, we'd somewhat anticipated that might be the course, given that we're
Right,
all here,
good.
as it were.
Well, that's what we will do about that. Just one or two preliminary matters which perhaps you were about to come to. The parties require permission for the new suite of skeleton arguments that we got at the last minute. We are minded to give permissions all round as required, but not without saying that it's rather disappointing that I think I'm afraid the blame is largely with the Secretary of State, that nobody appreciated that there hadn't been a skeleton argument dealing with a lot of the points until the last minute, and there had been no return saying that you were intending to rely on your original skeleton, permission skeleton, if that's what you were going to do. And the Government Legal Department, as probably the most regular litigant in this court, should really know how the system works. But some confusion was caused, I have to say, at our end for quite a long time before we worked out exactly where we were. But we got to the right place, so having got that off my chest, I won't say any more about it.
Well, can I just apologise then on behalf of really the legal team that you found yourself?
Well, I'm not getting individuals, but these rules are here for a purpose, and it's important, particularly regular litigants, understand them. Good. Okay, that's the skeletons. Now that well, I think Mr. McCullough, or rather his solicitors, have written, I think, asking for permission to withdraw the respondent's notice points. I have no idea whether that's required or not, but if it is of course given. And that does affect the timing. I think this was quite generously estimated anyway. With the respondent's notice points out, I would be disappointed if we can't finish comfortably within a day, because when all's said and done, the ground one is quite a narrow point of construction, and ground two, well, if we had a lot of the documents, the absence of which Mr. Justice Linden complained of, that might take some time to go through them, but we haven't. So there's a limited amount of time that can be spent on that. But anyway, let's see how we go.
Oh, yes.
Thank you.
And my learned friend and I sought to sort of agree a division of time. And we initially did it by reference to 1 day, and then we did it by reference to 2 days.
2 days? Well, you only ever have 1.5.
Well, but you know what? I'm sorry.
Yes, sorry, yes.
So we will try and go back to our original agreement. And certainly
Yes, I don't think. Sorry, I left the skeletons behind. Thank you, but I have them now.
Certainly, from my perspective, my lord, I took a sort of approach that Ryanair takes to time, whereby you give a lot more time and then you land well before.
We'll do one of those flourishes.
Exactly, and avoid
musical flourish.
Which I do hope you'll all get involved in. There we are. So, my lord, if I can, is there any further preliminary?
No, I don't think so. Unless either my lords or anyone else has talking points. Right, well, off we go.
Thank you. So, my lord, just the preliminary remarks. So, the court below held that the process for obtaining a second opinion was unlawful because it unlawfully prevented a decision being taken on and I'm going to refer to the medical reports as MLRs, based on the available evidence whilst the second opinion was obtained, and was provided for more than de minimis delay in reaching a decision on the MLR. And the court held that thereby rendered what, absent the guidance, we would say would be self-evidently lawful. So a decision to obtain further information, in this case a second opinion, and obviously to wait for that second opinion before you take a final decision. And so, against that background, since ordinarily there wouldn't be anything objectionable about obtaining further information, which undoubtedly was likely to be relevant, it's important to understand the context of why these proceedings were brought. And as to that, medical justice's key concerns really are twofold. The first was that the policy applies to MLRs, that is, a specific type of reports. There's no concern or suggestion that getting a second opinion in relation to any other evidence or other types of medical reports would be unlawful. It's the fact that it's MLRs. And then the second point is the time that the process takes. And so going back, dealing with those points in...
Well, hang on, why are we dealing with them? They're not issues before us.
No, but they are clearly issues. But those were the issues, really, which the court below was grappling with. Yep. Because
No, I thought they weren't. Mr. Justice Linden said at the beginning of his judgment, very wisely and reflecting on the wisdom of the parties, that everyone agreed that you weren't concerned with the merits of the policies. So questions about how long it took to get medical reports and so on wasn't for him to decide, and he didn't decide them.
No, but if the way the case was put below was that the Secretary of State, under the Secretary of State's guidance, had to consider the MLR without waiting for a review. And the point that was being effectively made was that, and Mr. Justice Linden does refer to this, was that under the previous system, effectively MLRs had to be accepted, save for exceptional circumstances. And the SOP, or the second opinion policy, introduced a system whereby effectively the MLRs were subject to a scrutiny which they weren't previously subject to. And although Mr. Justice Linden then decided...
Okay, well, when the judge, as I've just done, jumps in, it often takes up, trying to save time, it often ends up spending more time. We'll trust you, Mr. Payne. You make the points you want to make, but do remember we're ultimately concerned with the question of what the guidance means.
Absolutely, Martin. As I said, this was just very short sort of context as to, in terms of the background to the litigation. So my lord, just going back, just in terms of the position of the MLRs, one might have thought that obtaining a medical opinion to assist caseworkers who aren't medically trained in assessing the weight of medical evidence was not objectionable. And indeed, there is case law, and it's in the bundle. It's a case called DK, where effectively the claimants were arguing the opposite. They were saying the Secretary was under a duty, in terms of discharging intenside obligations, to obtain medical reports. And that is why, my lord, I was referring to trying to explain the reason why this issue arose in this case at all. And that is because the concern is that the SOP was effectively a change which allowed a scrutiny of something that previously wasn't really subject to scrutiny. And the second point, my lord, it relates to the time that this, and although Mr. Justice Linden referred to it as an obligation, a de minimis, no more than a de minimis delay, but the concern really was that the time that it took. And although, as my lord rightly says, Mr. Justice Linden said at the outset that the merits of the sort of, or the reasonableness of the time that was provided for was not subject to scrutiny. Ultimately, Mr. Justice Linden did decide that the obligation that was applicable to the Secretariat was to take a decision with de minimis delay. So against that backdrop, can I turn to the various guidances? So in the core, can I start with the statutory guidance, and that's at 287.
Yes.
And if you turn to 289, that's the first page. It should be entitled Purpose and Background.
Yep.
And so the opening sentences are important. The first sentence says, this guidance specifies the matters to be taken into account in accordance with Section 59 when determining whether a person would be particularly vulnerable to harm if they were detained. And then the sentence carries on. So what we say is important in that sentence are the words taken into account and when determining whether a person. Because this guidance, we say, is nothing about process, doesn't deal with process. What it deals with is how you look at a decision. So when you're taking the decision, what do you look for? What are the criteria you apply in taking the decision? What it doesn't say, and this guidance doesn't cover, is the process for taking a decision. And it's against that backdrop that you look at the words available, because the word our case is that a reference or a reminder to take into account all the information that's available when taking a decision is no more than that. It's just a reminder of a basic principle of how you take a decision. And then further down, if you have it in a bundle, it's near the top hole punch. There's the sentence which says, about 15 lines down, it aims to introduce a more holistic approach to the consideration of individual circumstances, ensuring that genuine cases are consistently identified. So we say that each of those provisions is consistent with this guidance, the objective of this guidance being to promote better, more rounded, more informed decision maker. And the word holistic gives the sense, or gives is consistent with obtaining information to provide a more rounded and better informed decision. The other points are genuine cases, and that highlights the need to actually make a proper assessment and to have the proper evidence available. And the word consistent highlights the fact that the approach that's taken in the assessment of evidence across the board should be as similar as possible. And so having a medical, we submit that having a second opinion is entirely consistent with each of those considerations. Paragraph 3 makes it clear that even if a person is at risk, and it's the fourth sentence, which says, within this context, it will remain appropriate to detain individuals at risk if it's necessary in order to remove them. And Paragraph 4 is the first reference to available evidence. And again, you can see from, if you read the sentence, the first sentence to yourself, from the words "an assessment will be made," you can see that the reference to available evidence is by reference to the assessment that's being made. If you turn over to page 290, you have the two bullet points, third from the bottom and second from the bottom, which the third from the bottom again refers to the weight of evidence and the level of risk needing to be considered. And then again, the second bullet point is the reference to available is again by reference to the actual assessment that's been undertaken.
Sorry, this is the second bullet point from the bottom.
My lord, yes.
Yeah.
And then if you could turn to page 291, you have paragraph 7 and the second bullet point down, which refers to the various sources of the obligation to consider the sort of the vulnerability of detainees, and you've got this very broad obligation, basically aware of medical or other professional evidence, of observational evidence, in terms of identifying those who are vulnerable. So, and then paragraph 8, again.
So what's the point you're making from 7?
Well, because I will be coming to the point as to whether, in fact, the consideration of vulnerability is in fact suspended during the second opinion process.
Okay. Yep.
And paragraph 8 is again a reference to on the basis of the available evidence, and it's being, the references there is in terms of assessing whether someone is at risk. And two points I would like to make actually in relation to 8 and 9 is, if you seem to have, you look at the evidence and you look at someone who is, whether they are at risk, and then if you look at 9, once the individual has been identified at being risk, you then look at the level of evidence available, again, in support, and weigh it against, and weight that should be attributed to it, and then you then, against that, the caseworker weighs the likely risk of harm, if detained, and the period identified. So it's on any view, it's not sort of one process, and the second bit of the process ensures that weight of evidence needs to be considered. And in that context, again, we say there's nothing there at all which would suggest to the reasonable, well, a case where adopting a reasonable interpretation that prevents additional information being obtained.
Hang on. Yep.
292. This is where you have the various levels. The third bullet point from the top is level 3.
Interestingly, well, not, I mean, but just to get the concept right, they're evidence levels, they're not risk levels.
Absolutely.
Although there is obviously some sort of equation between how much someone is at risk and how strong the evidence is. I'm not sure it's quite logical. That's not an issue for us at the moment.
No, but I was going to just touch on that point.
I see, right.
Well, just because part of the claimant's case is that any delay gives rise to a significant risk. You know, as soon as there's an MLR, any delay gives rise to a significant risk of harm. But that, with respect, is to confuse what level 3 means and what, in fact, the contents of the report are. Because you can have a level 3 report, you have to attach a lot of weight to it, but the report could, in fact, identify relatively either long-term or relatively limited risk. So it's important not to equate level 3 with high risk.
But it does say in the third line, likely to cause harm.
Harm, my lord, yes, but without absolutely, but without referring though to level of harm. It doesn't say So, for example, although I wasn't going to take you to, if you look at the medical reports or medical evidence in terms of conditions, the Secretary only effectively responds to that type of evidence if there's evidence that it's a serious condition, whereas here it's just risk of harm.
Hang on. If they are adults at risk at all, there is something in their history or the condition they're suffering from which would likely to render them particularly vulnerable to harm. So everybody in the bullets at the top of page 292 is someone who is particularly likely to be particularly vulnerable to harm. But as I said before, each of the bullets is concerned with how strong the evidence is that that is the case.
Yes.
So I put that rather badly, haven't I? But the fundamental point I was putting to you is right. I think you accepted that these three levels are to do with how strong the case is, effectively. Your point is that...
No, I think it's slightly different, my lord. I think the three levels are to do with the weight you attach to the evidence. So
no, sorry, that's what I meant by how strong the case is.
Yeah, okay. All right. So, my lord, if you mean how strong the case is, how strong the support for whatever the whatever view expressed, then yes. But if you're saying that how strong the case is, i.e., it's a high risk, then the Secretary wouldn't accept that. Because obviously it all depends on what the contents of the report. So the Secretary's position is that the contents of the report, which fall within level 3, need to be given significant weight.
So you say a self-declaration could imply a very high level of risk, and professional evidence might, to the contrary, suggest a low level of risk.
Yeah, so, well, maybe not risk, my lord, but low level of harm.
Of harm, yes.
But does that work? Because in that case, as the quality of the evidence goes up from 1, 2, and 3, there's a suggestion, certainly at 3, that the risk is also going up.
I think that must be correct, because in order to fit within level 3, you need to have an identification of a condition and likely risk of harm. And if you're going to attach greater weight,
but isn't the condition is itself one that's likely to render them particularly vulnerable to harm if they're placed in detention? That's the definition of adult at risk in 7.
My lord, yes, and so that's why I took you to the 8 and 9, my lord, which is that you identify whether they are particularly vulnerable, and then you look at the actual evidence, as to whether it says the likely risk of harm in the period identified. So, for example, my lord, at a very simple level, you could have a medical report which says, an MLR which says, this person he's vulnerable, he's at risk of harm for long-term detention. And in fact, the detention could be for a short period because you've got removal directions or something set in a short period of time. So you attach a lot of weight because it's a level 3 to that medical assessment. But you don't have to, just because it's a level 3 assessment doesn't mean that there's necessarily a high risk of harm. There is some risk of harm, because otherwise it wouldn't fit within level 3. But you can't have a system whereby, without knowing the contents of the report, you immediately say, just by virtue of the report, there's a high risk of harm, which you have to attach weight to. In a sense, the example I just gave actually is, you can see really in the first line of the third bullet point. So you have a report that states that someone is at risk and a period of detention would be likely to cause harm. If you're looking at the third bullet point, my lord, on page 292, the example I just gave, it says, first sentence says, the report states that an individual is at risk and a period of detention would likely to cause harm.
But the difference between 2 and 3, ignore, is a complication because 2 also refers to official documentary evidence. But talking about professional evidence, the difference between 2 and 3 is that the professional evidence indicates that the individual is an adult at risk. Therefore, looking back at the definition in 7, is particularly vulnerable to harm if they're placed in detention.
Yep.
Right? So that's what 2 is. 3 is the same, down to halfway through the second line, and that a period of detention will be likely to cause harm. But haven't you already established that by saying that they're a person at risk? Is there a difference between being particularly vulnerable to harm and being likely to suffer harm? Presumably there is in the drafting.
Well, my lord, yes, because you could just have someone saying, for example, if you go down to paragraph 11.
Well, just let me.
I will. No, it's just in answer. I'm trying to answer. I'm not.
I know you are, but I'm just trying to write down. All right. Take me to 11. Yep.
Well, so if you look at this, my lord, if you look at the second bullet point under 11, you can be identified in an MLR not as sort of suffering from an actual condition, but simply as being a victim of trafficking. Now without minimising.
Yes, sorry, I've been slow. I see. So that's really crucial to the way this is drafted. Vulnerability to harm is not the same as likelihood of suffering harm. Thank you. Sorry, it took me a long time to get there, but it doesn't leap from the page. Right.
And then, Mark, can I just ask you then just to go back to paragraph 10 for a second? Well, I haven't taken you to it, but go to paragraph 10, which is at 292.
Yes.
And if you could just read that to yourselves, because what that provides is that you can effectively look at other evidence, in this case a tribunal finding, tribunal determination. You can obtain that. You can look at the credibility findings, and that is a way where, if they're different or they discount the factual basis upon which the MLR has been provided, would be a reason for downgrading or reconsidering the level. So the statutory guidance itself provides for levels to be considered or reviewed.
So, for example, someone might have been thought at the time of the initial assessment to be level 3, and as a result not detained. But when you look at a tribunal that says plausibly this person, nothing they say can be trusted, and the whole assessment is based on their account, you would say, oh, well, we no longer think he's level 3, it's level 1, really. It's a self-declaration and not a very reliable one at that, and so we will detain him. Is that's how it works?
That's the concept. I mean,
yeah.
I mean, to be honest, my lord, I mean, it might.
It can never work the other way, can it? I don't see how credibility concerns would.
Well, I think, my lord. I mean, obviously, this is guidance. So I think you can be sort of. It doesn't. It's not prescriptive in the sense it doesn't.
No, I understand that, but is 10 intended to cover cases where the court or tribunal you may initially have had a rather poor self-declaration, wasn't given a lot of weight, and the tribunal then, maybe the first-tier tribunal, someone finds they are indeed a victim of trafficking or an asylum seeker and have suffered torture or whatever it may be, and suddenly you think, oh, well, I know it's only a self-declaration up to now, and we have therefore been detaining them, but we're now going to release them because we see a tribunal which is convinced that they were actually badly tortured. So it could work both ways. Yeah.
My Lord, yes, and certainly I've done quite a few cases where the challenge is to effect an initial rejection of an account, and the detention decision based on that basis, then subsequently the acceptance of the account,
Yes.
and on any view, the detention has to be reviewed at that stage, and a view taken. It's just going back to MLR, medical legal reports, there is, as you'll see, quite a high threshold though. So, for example, it would be vulnerable to challenge to simply say, oh, there's been a general rejection of credibility, and on that basis, simply we just reject the medical report. The more common basis for focus of rejection is where effectively a specific account that's relied on as the basis for the MLR has been rejected. That's a stronger case.
I see that. But the point, before I started asking you questions about it, your fundamental point is that built into this is the possibility of reconsideration.
Yeah, and the point which the second point which you asked me about, well, what about if it flips over? I accept it's not specifically provided for in the statutory guidance, but certainly, as I've said, there've been I've done many cases where the flip side is being relied on by the claimant.
Yeah, I mean, the flavour of it is undoubtedly, as I put you first, but actually if you look at the literal wording, I think it would cover a determination from court or tribunal about the credibility of a person's account. You might get a tribunal say, I found him wholly credible.
Yeah, absolutely. Yeah. But you will also see, my lord, that the word available isn't there. And then in indicators of risk, that's paragraph 11. I've taken you through them. Well, I haven't, but I've just referred you to one of them. But if you look at paragraph 12, it says, and referring to the indicators of risk, the above list is not intended to be exhaustive. Other relevant conditions taken into account, as well as the available evidence of conditional traumatic events can change. I should have read the last sentence. In addition, the nature and severity of a condition, as well as the available evidence of a conditional traumatic events, can change over time. So they are effectively squarely saying, actually, this is an ongoing process. You've got to look at available evidence or evidence that becomes available. And there's certainly no suggestion that you need to do a sort of freeze frame assessment of evidence as suggested, we say, by Mr. Justice Linden. And then just in terms of the latter consideration, which really doesn't...
Well, I don't know. This could cut both ways from your point of view, couldn't it? You could say that the Secretary of State is obviously right. There must be some system whereby you can take a further view and make your decision on the best available evidence, or the best evidence, you like the word available. And therefore you say no need to do a freeze frame at the moment the issue first arises. The counter-argument might be, well, no, the fact that there's a possibility of review and reconsideration is a good reason why you ought to do one straight away, knowing that it's not forever, and if you, in the meantime, get a second opinion, you can reconsider.
Well, dealing with the latter point, then, that argument, even if correct, wouldn't preclude the second opinion being obtained. But
no, but it might prevail. It might mean that you shouldn't take a well, to put it crudely, you shouldn't keep someone in detention or detain them while you're waiting for the second opinion, if the material available at the first stage suggests they oughtn't be in detention. You can always go and get them later.
But there's nothing that says, even on the basis that, for example, a caseworker looks at the material, says it's level 3 weight, that says, well, I need this considered in order to reach a final view on the weight. That consideration process, in terms of looking at the available evidence, is taking place. It's not that the evidence isn't being considered. It is being considered, and it's being considered by a medical expert in reaching the decision on the evidence.
Yeah, thank you.
Can I ask you then to turn to the interim guidance, the SOP, and starts at 295 is the opening page. 297 is where I'd like to take you to first. And it's the opening sentence again. If you read it, you can see this is about process, not substantive consideration, process. And then the second sentence says the guidance sets out how the second opinion should be considered in determining whether detention is appropriate in line with adult at risk. And then it should be read with other policies. If you can turn to 298, please.
You're going to explain. This is just. I mean, what we've just been looking at is statutory guidance.
Yep.
It's not actually described on the cover sheet as statutory guidance. It's just described as, as guidance. But I suppose the heading is Immigration Act 2016. Presumably, if you look at the fine print, is there somewhere a reference to the fact that this is...
It says it's issued pursuant to Section 59, and Section
Yes.
59 says that it has to be...
Yes, exactly. So that, whereas this is policy guidance,
Yep.
and not, so it's spelled out that it's a different kind of guidance.
It will, by implication, it is.
Yeah. Thank you.
My Lord, if you could then turn to 298, please. And the second paragraph refers to the AAR policy guidance. That's the last one I'm going to take you to. And again, you can if you look at it, the AAR policy, again, it's quality standards. So not process, quality standards. And then it says this guidance, the SOP guidance, is designed to work in conjunction with the standards and introduce an additional clinical input to assist decision making for those who may be vulnerable in immigration detention. So this is a process assisting standards and the standards and the approach to the substantive decision making is guidance is in the statutory guidance and the AAR.
Sorry, you'll have to forgive me. I confused myself and therefore confused you. I thought this was the page we were looking at first, but no, you were looking at 297 first.
I was, my Lord. That was
Yes, that's my fault.
and then I was turned to 298. And
Yes.
it was the second paragraph.
Yes.
So if you wouldn't mind just reading that to yourself.
But what is the AAR?
That's the caseworker policy, and it's the third one I'm going to take.
Yes, I see. Thank you. Thank you. Yep. You carry on. I've got myself orientated now.
And then, my Lord, I'm not going to take you through the various timeframes because they are sort of set out, in terms of the individual decision making. The stages of passing material on and appointments and interviews. Can I ask you to turn to 299?
Can I perhaps just ask this? Those are quite carefully summarised by Mr. Justice Linden. You've got no problem with his summary.
No, they are.
Thank you.
No, but yeah.
Yeah,
But I suppose the only point I was going to make in terms of my general submissions was that those are obviously extremes if every single thing goes as wrong as it can. And as I think if you've read this, you'll all have picked up the fact that if there's an error along the way, so like the 7-day time frame isn't
then they have to go ahead with what they've got.
Yeah.
Yeah.
And even, my Lord, if you don't give a 2-day notice, in relation to the 7-day appointment, it's got to go as well. So we do accept that the overall maximum, if everything went wrong and a report was received on a Friday next to the weekend or something, that's the maximum potential.
Yes, I haven't worked it out. It's something like 25 days.
Exactly. So, and we're not going to certainly not going to quibble. Page 299. Having said I'm not going to take you to data, I'll just take you to this one because it's referring the external medical report. There should be a heading, and this has got to be within a day of receiving the report. And the paragraph I'd like you to read, please, is the one at the bottom, which starts in line.
Yep.
My Lord, before I make submissions on that paragraph, could you then turn to page 304, please? And you should have a heading, the second opinion report. And this, could you read, please, the second paragraph from the bottom and the last paragraph? Well, the first 5 lines of the last paragraph.
The one starting statutory detained.
My Lord, yes. Can you read that one in its entirety and then
I see.
The paragraph, but after it, the first 5 lines. So the significance of this is that there is a bit, we would submit some confusion in relation in the judgment as to the processes. Because what the second opinion process provides for is when an MLR is received and a caseworker is considering, by reference to the MLR, what weight to attach to it, that's passed on for a second opinion. The second opinion is then returned and the caseworker takes a decision. There is, however, an entirely freestanding obligation on those, the Secretary of State and those in maintaining detention, to keep an ongoing review of the welfare, the vulnerability, the health of the person who's detained. And that continues to operate in parallel to the SOP. And when I take you to the AAR, what you'll see is that, particularly Rule 35, which I can take you to a case if you aren't aware of it, but Rule 35 places a mandatory obligation on the healthcare staff who operate in prisons and IRCs. I'm not sure about prisons, but IRCs actually, to draw and refer anybody who's perceived as vulnerable in terms of detention and whose continuing detention is of concern. As you've seen from the first page I drew your attention to, the MLRs are received and has to be immediately sent to the healthcare team. So the healthcare team are aware of what's in the report and they're not having to wait for a second opinion. They can simply look at that report, and if they consider that there's an immediate risk or some really imminent risk, they are obliged under Rule 35 to record that, communicate that there's a real impact of continuing detention.
Can I just understand how things fit together in one respect?
Yep.
So it says there will be no requirement to change the AAR level based on the external medical report at this point. And that's referring back to the levels we saw in the statutory guidance.
My Lord, yes.
So it's saying we don't have to treat it as level 3 at this stage.
Yeah.
And what's the significance of that?
Well, it's significant, my Lord, in terms of the caseworker. So the caseworker who's deciding, based on the MLR, what is the risk I need to weigh up against the immigration considerations. Yep. If it's a level 3, you attach a lot of weight to it. But of course, for the healthcare team or the healthcare professionals in a prison setting, or the IRC, I can't remember what IRC stands for, but the detention removal centres, they just look at the medical report, as medical experts.
I follow that, and I
Sorry.
don't think this matters, but just so I understand. So suppose you were supposed to treat it as level 3 at that point. What would the impact of that be?
That you would, so the caseworker, so the caseworker would then have to look at the assessment of the risk of harm of continuing detention in the MLR and weigh that against the countervailing immigration considerations.
So that is in the context of paragraph 13 of the statutory guidance, is it? page 293.
My Lord, yes.
So is the idea that as soon as you treat it as level 3, you have to undertake the paragraph 13 exercise?
Well, that's the claimant's case. Oh, sorry, the respondent's case.
Yes, I see.
And the Secretary of State's case is you receive a report and you are entitled to take reasonable steps to, as part of your consideration of the level, to obtain further information. So you could obtain a tribunal judgment, or you could attain, in this case, a second level.
So just to understand again, level 3. You get to level 3 if you've got professional evidence stating that there's such and such a risk. So on the face of it, you've got that evidence, regardless of whether you get to your second opinion or not.
No, because the second opinion policy provides that depending on what the medical opinion is, you reconsider the level of risk. No, sorry, I've got myself confused now. Level of weight to attach to the report.
So I see.
So you have effectively, really, what's happening is, although in a practical terms, you've got one level 3 form of evidence, i.e. something you need to attach significant weight to, and as opposed to a caseworker making that assessment who isn't medically trained, you get effectively another level 3 report by an expert, and then the caseworker is able to look at those reports and determine what overall level to attach to the conclusions.
Well, caseworkers are still having to make a decision then, because the external one may say very high risk. The one commissioned by the Home Office may say very low risk. It's not suggested that he or she is obliged to accept the later report.
Yep.
He still has to make a decision
Yep.
between the two.
Yep.
And the external one may be very persuasive, and the
Yep.
Home Office one may be very perfunctory, or the other way around.
Absolutely. And the Home Office one could be based on evidence not available to the original MLS.
Yes. So just to understand, it isn't on your case the position that once you've got a report satisfying the requirements of the statutory guidance, you treat that as a level 3 evidence case. Even if you've got a report satisfying those conditions, you may not treat it as an evidence level 3 case. So it isn't that you weigh the level 3 evidence against the other evidence. You say, well, you don't treat it as level 3 at all.
Well, to be honest, it's quite difficult to explain my reference to levels, but if you look at, so for example, paragraph 10, which refers to tribunal evidence, can you see you sort of the way it's formulated is you reconsider the level.
But it says you can reconsider the weight. Does that mean you can reconsider the level?
The levels really represent weight, don't they?
That's it, you see, because I mean it's not brilliantly articulated, but you see, because the levels don't identify the level of risk; they just identify the level of weight, and so it's a sort of a bit of a sort of form odd process in the way it's articulated, whereby really what this says is you get additional evidence and you review the weight. So you start with level 3 and then you can effectively downgrade it.
Let's take the most obvious thing. I mean, there are lots of examples. Presumably one example is a detainee or potential detainee who says, I'm going to commit suicide. And if it's only a self-declaration, you afford that limited weight. And probably that means it's unlikely to outweigh the immigration reasons why you want to detain them, namely that you think you'll be able to return them to where they came from within a few weeks. Then you get a social worker or a GP saying, I think he is going to commit suicide. That's evidence level 2. Well, he won't say, I think he's going to say, I think there's a real risk that he will, yes?
I would have thought perhaps a clearer example would be a GP saying he's a very vulnerable person.
Well, that's not the language the GP is likely to use, is it? That's language which caseworkers use. GP is more likely to talk about particular medical conditions, suicidal ideation, or extreme depression with suicidal tendencies, or whatever. That's what a GP is likely to say.
I agree, but then a GP. But if you look at the wording of two, the difference between 2 and 3. Two is medical evidence that just shows someone is at risk. Yeah, 3 is at risk because they're effectively by virtue of remaining in detention. So I agree. So the GP could sort of say there's a freestanding risk of suicide. But what's more common is a GP or someone saying he's a vulnerable person because he's been trafficked or something, or he's a vulnerable person because of his experience, but without linking it to.
Well, the trouble is the definition of vulnerable, as you yourself pointed out, the kind of factors that make you vulnerable are very varied. They can just be to do with your experience, as you say. A trafficked person is in a general sense vulnerable, but they will vary enormously according to their resilience. Some of them, despite having been through terrible experiences, may not actually be at risk of suicide. And some may.
Yeah. So, my lord, I'm not saying your example is necessarily a bad one. I'm just saying that your example might be susceptible to an argument, whereas a clear-cut example is for 2 is simply medical evidence suggesting vulnerability. And that's a nice clear-cut piece of.
Sorry, we got rather a long way away from my lord's question, which is quite an important one.
I've lost track of it as well.
I must admit, I have too, and maybe you've answered this along the way, Mr. Payne. I suspect you have. You say that even though you have received professional evidence, such as is described in the 3rd bullet point at the top of 292, and therefore, on the face of it, that bullet point applies and you're to be treated as having evidence level 3, actually, you don't have to reach that conclusion then, and if more evidence becomes available, you can change the level. So it's not a matter of weighing evidence level 3 against other evidence. It's a matter of changing the level of the evidence.
The Secretary's position is that when evidence is received which meets the level 3 criteria, at that stage it is level 3 evidence. The Secretary's position is that in considering that level 3 evidence, the Secretary is entitled, for example, to obtain a judgment or to obtain another report. And if it receives that report, then the Secretary is entitled to review whether it's a level 3, whether level 3 weight should properly be attributed to that report.
The word used is reconsider. If we were being very technical about this, that's why I asked you about this point cutting both ways. Para 10, if we were reading it very literally, implies a decision that someone is level 3, but reconsidered in the light of subsequent evidence. But I think that's not quite your case. Your case is that when you receive an external medical report which satisfies level 3, you don't immediately have to go on to make a detention decision.
That's exactly right.
And the actual decision we're talking about is a decision whether or not to detain, or as it might be, to continue to detain. You can, as it were, park that evidence and get some other evidence within a tight time frame, and you don't make your decision until you've got that further evidence.
Yes, we would just 2 slight nuances that. First of all, the issue of whether it's a consideration or reconsideration, we would say is a red herring, because the issue is, if you look at 292, the issue of whether something's a level 3 report is defined by reference to the status of the person providing the report and whether there is a risk identified. So that's what you start with. And then if you look at paragraph 10, the word reconsideration is used there. And it doesn't mean you're reviewing your decision as to whether it's a level 3. It means you're reviewing whether it is in fact a level 3 document. So you can either look at it as part of it, and we would invite you to look at it as part of an ongoing consideration process. So you get a level 3 report, you need to consider the report. The caseworker is entitled to consider matters that go to whether or not it is in fact a level 3 report. As part of that, the caseworker can obtain, for example, tribunal determination.
Well, hang on. Even that, I see the point you're making, but even that's not quite the right way of putting it. A report of the kind referred to in bullet point will always be, ignore cases where they're badly drafted, trying to see what they're saying. But if it says explicitly, I am a GP, doctor, I state that he is at risk by reference to the criteria in para 7, which I spell out, and I say that a period of detention will be likely to cause harm. You will never, even if you get a further report, you won't be reconsidering whether that is a level 3 report. It is a level 3 report. What you'll be reconsidering is whether you're going to act on that report or on the later report. Well, not reconsidering. What you'll have to decide is whether to act on that report. It will always be a level 3 report because it says what it says.
My Lord, I accept that. And I think part of the difficulty is trying to maintain or use this level 3, because the reality is why you're obtaining the second report is to consider the weight to be attached to the MLR. But under the process, the weight is defined by level.
And I absolutely follow that the logic is, look, you get a second report or whatever, that affects the weight that should be attached to the first report. I do have a bit of difficulty reconciling what seems to be the definition of a level 3 report with the idea that you potentially decide it isn't. Looking at the guidance, it says there will be no requirement to change the AAR level based on the external medical report at this point. And on the face of it, it is a level 3 report. It's just you might not want to attach any weight to it in the end.
Well, the AAR is effectively the risk. So I will take you to the AAR policy because so we can look at what a level 3 AAR is.
Okay.
But can I just ask you, just because of this issue that's risen about what the proper approach is, whether it's level 3, whether it's weight. If you go back to paragraph 9 of the statutory guidance. So 8 is you identified someone as being at risk, and then 9 is once you've identified someone as being at risk, you look at the level of evidence available and the weight. And so that's this process. Yeah? You've got evidence, you've got a level, and then you look at the weight. And that's all wrapped up in the consideration and the decision that needs to be made. And it's very important not to confuse consideration and decision.
And in the end, that all feeds into paragraph 13.
Yeah.
That's the decision.
Can I just ask you on paragraph 13 before we leave it? The presumption, once you've got level 1 evidence, is that a person won't be detained. Do immigration control factors include getting further evidence?
Medical evidence?
Yeah.
I wouldn't. But I don't think it's specifically provided for.
It's not logical that it should, is it? Because that's what goes. Medical evidence is on one side of the balance, i.e. against detention. The immigration factors are about how important it is that we should detain him.
Yeah, but that's true. But the reason I wasn't excluding it was as you'll see when we go to the AAR, the key factor when you're looking at this is length of detention. So you might get a report that says prolonged detention at risk. So you might go back and say, well, this is a short period of detention. That's what, removals in a month. What's your view? And I appreciate, my lord, you could say, well, that's part of the initial assessment. But when you're weighing up the weight, it could go in either sort of either issue. I mean, we are at the moment, with respect to drawing a slightly artificial division between things which doesn't really reflect the reality.
I'm only doing it because I'm trying to make sense of the document.
No, I'm not criticising, but I'm just saying that it is a sort of holistic process whereby any evidence that is available should be weighed up.
So if you have a mere self-declaration, that is enough to make you a person at risk.
Not necessarily, because it's very, very little weight is attached to it.
Well, is that right? Because if you look at 7, it says an individual will be regarded as being an adult at risk if they declare. So at that point, you've got somebody at risk.
Yeah.
And then if you go through to 13, the presumption is that once an individual is regarded as being at risk, they should not be detained. So there's a presumption against detention. But then that's qualified by the next sentence. Any risk factors identified and evidence in support will be balanced. And you say to yourself, well, look, all I've got is a self-declaration. It's not very convincing. That's only level 1. And there's a need for immigration control, so I'm not going to act on it.
Well,
go ahead first.
I accept this isn't fantastically drafted, but can we just go through your point? Because in terms of 70, you're quite right, it says will be at risk. Yep. But then you need to look at 8 and 9, because effectively what this policy is trying to say is that 8 means you're at risk, which is the route into 9, which means you then look at the weight of the evidence. So it doesn't mean if someone says, I'm going to commit suicide tomorrow, you need to accept that statement and look at risk by reference to that being the case. You said, so right, well, he has said something, so he is potentially at risk. We then look at the weight of the evidence.
Well, he is at risk, not potentially at risk.
For the purposes of the guidance.
Yes,
that's what Paris said.
but then, no, I accept that,
But what 9 shows is, this is all the ultimate decision being taken is an assessment of whether they should be detained. They are at risk, but should they be detained? That's what the heading above 9 says. And the substance of 9 says, once they've been identified as being at risk, so they are at risk, consideration should be given to the level of the evidence in support and the weight that should be afforded to that evidence in order to assess the likely risk of harm. So the fact that you are at risk doesn't necessarily, it's an odd phrase. I don't think it means it doesn't mean that it has been irrevocably decided that you will suffer harm. It means you're the kind of person who might suffer harm.
That's exactly it.
Vulnerable.
That's exactly it. And then you've got to go so I mean, if someone just, says something, let's say, fairly ludicrous, that on the reading, I accept on the strict reading of the guidance, that means he's at risk. But it doesn't mean that the secretary has to accept the account that's provided and assess risk by reference to that. He looks at the weight and the level of evidence and makes that assessment in terms of likely risk of harm by reference to his assessment of the evidence.
And is that only a paragraph 13 question, or does it come in somewhere else?
No, it isn't. It's a sort of risk of harm question, which is then balanced against the immigration countervailing.
So I'm just firming this up in my own mind. I know I've said this before. These are people who, because they are at risk, that means they are vulnerable to harm.
That's right.
If detained.
That's right.
But the structure of this is that still means that you have got to assess the likelihood of harm. They may be vulnerable, but the harm may be very little.
That's right.
And one factor in deciding that question is how strong is the evidence, effectively the evidence that they will suffer harm.
And the nature of harm.
And the nature of harm.
By reference
But you need to know that because there is a risk by definition, that's why you're thinking about it. But how big is it? How big is the risk of harm? And what kind of harm? So that you can balance that against the immigration factors. And what 10 is doing is giving you this rather mechanistic guidance as to what weight to attach to the evidence.
to try and achieve sort of some form of sort of consistency.
9 rather than 10.
Yeah, it's 9. I wasn't,
Sorry,
I wasn't
I
going
said
to.
10, I meant 9. Yes.
I wasn't going to correct.
So you've got different concepts: vulnerability, likelihood of harm, weight of evidence of likelihood of harm.
In fact, the statutory wording is particularly vulnerable in paragraph 7, isn't it?
Yes. Thank you. Particular vulnerability. I mean, although you've said one's assessing degree of likelihood and degree of harm, and saying they're separate things, which conceptually they clearly are. Suicide is the ultimate harm, so very, very serious harm if it happens. But there could be other forms of harm. Someone might have a kind of illness which means that they will be in pain or whatever. But the degree of likelihood is a completely separate question. You might have quite a low risk, but of a serious form of harm.
Yep.
Or you might have quite a high risk, but of comparatively less serious form of harm. But these are subtleties that really aren't addressed.
This is very broad brush.
Yes.
And my lord, just using your latter example, so high risk, low harm. High risk, low harm could mean that it can properly be managed in detention. So you would, the healthcare.
Right.
Yeah. But I'm just saying that it's not just anyhow.
You could have someone who's a diabetic, for example.
Yeah.
And as long as you have a good diabetic support team, that won't be a problem. They'll be given the red
But it's almost impossible for well, I'm not going to go that high, but it's not easy for someone who isn't medically trained to identify whether, for example, treatment in a detention centre, how much that would alleviate a risk, which is what the SOP process is designed. That's the sort of information that can be provided and made available.
Can I just ask, while we're still on the paragraphs 9 and the level of risk, you mentioned Rule 35. I have some recollection that if you get to level 3, you get Rule 35. Is that right, or something?
Can I come back to you on that?
Yes, there may be a misrecollection. Just to chase that down.
Yeah, I will. I will certainly confirm that.
Thank you.
But when I'm sorry to be picking away at this.
No.
It's jolly difficult. If you look at 9, when you're saying that a self-declaration should be afforded limited weight, that goes what? To credibility? I mean, you don't really believe them?
Yes.
And just to be clear, is there any guidance as to what you can do? You get in a self-declaration saying, I've got this really serious condition. You're showing us the second opinion policy in relation to MLRs. Is there anything explaining what you do if you have this self-declaration?
Well, a freestanding policy.
Yes, or
well, there's a little bit in the AR policy, which I'll take you to. But the reality is, for example, a classic level 1 case would be someone say, I'm going to commit suicide. I mean, let's say a really extreme level 1 case would be someone say, I'm going to commit suicide, and there actually being a medical thing from the healthcare team saying, he's always saying this, it's a load of, it's not correct. And so that's non-arguably a level 1 case. So it's still level 1, it's still a risk, but you look at that evidence and you're entitled to either discount it or attach a little weight.
And just to be clear, I mean, since we're dealing with questions of delay here to an extent, so suppose there hasn't been any previous healthcare team assessment, and then you get in the self-declaration saying this is terrible. Is there any guidance as to what you then do? I mean, do you make an immediate decision based on the self-declaration, or do you delay at that stage to think about it a bit more?
Well, it depends how the self-declaration is communicated. When someone goes into detention, they need to have a medical review within, I think it's actually within 2 hours or 3 hours. It depends which facility. And then if they raise concerns, that needs to be recorded. It's a Rule 34 meeting, and it gets recorded in a Rule 35 report. And if that report identifies vulnerability, that needs to be considered by the caseworker to decide whether continuing detention is lawful.
Yes, I see.
And that obligation on the healthcare team is continuing in terms of Rule 35. So they get, for example, as I said, one point which is important, is that the MLR is immediately, within a day, passed on to the healthcare team, who aren't under any constraints in terms of how they look at it, when they look at it, or anything.
Conceptually, this is all happening before someone is detained.
I know.
Because an assessment of whether an individual at risk should be detained, that's what.
Well,
but in the real world, are we tending to deal with whether they should continue to be detained, having on day 1? They're brought in, well, that's the first time that somebody interviewed, I don't know.
I'll ask my juniors to check this, but I must admit, I'd always understood, and all the other guidances refer to making this assessment prior to detention if someone hasn't yet been detained, and continuing during detention.
But realistically, there are 2 ways in which people are detained. One is if they're apprehended in the community by somebody who's out looking for people who are trying to escape, and then they will be detained there and then by a squad and taken to a detention centre, and presumably that's where the definitive decision is taken. So in a sense they're already detained, but it's the very start of the process. The other way they're detained is they turn up at Luna House, if it is still Luna House, or for their regular reporting, and they're told, you are detained. And again, they're not kept at Luna House, they're taken to a detention centre. So the kinds of decisions we're taking were not really before you even go and get someone. Well, I don't know, in the Luna House case, there will have been an assessment, so-and-so's coming in tomorrow, we know we can fly him out next week. Let's look at his file.
That's what the caseworker in an ideal situation does.
Is it still Luna House, or have I invented that?
No, I spent many years in Luna House.
At any rate, if you're in London, yes, I see.
It bears no resemblance to his name, does it, in terms of certainly not very sort of inspiring. Anyhow.
Oh, I thought you would Luna, I always think of the moon as being cold and bleak.
That's absolutely. Well, that's true, actually. Yeah. Depends what you take by Luna. Okay. So, So have I dealt? Any other questions?
Sorry, this has been rather undisciplined, and it's largely my fault. But this does take a bit of thinking all the way into.
It does. I'm glad.
Yes, I think we've done enough of it. I don't promise you we'll not have to do some more later.
But I'm glad I took.
We haven't got very far into. We haven't yet gone to the caseworker report.
There isn't one.
So what's it? Caseworker guidance.
Oh yes,
so a slip of the tongue.
Yeah. That's the one I was going to go to next. If that's okay. That's in the supplemental bundle. And it starts at page 200. and it's quite a lengthy document. So I'm going to take you just to the passage I say are relevant. So, given the court's questions, at page 204, there's a heading: Assessment of General Principles. Could you read that to yourselves, please?
Which page did you say, sorry?
Sorry, 204, my lord.
204, yeah, thank you. And this is the version for 20th of April 2023.
It was the one considered by Mr. Justice Linden. It's not the current.
Fine.
Version.
No, that's fine. Which paragraph do you want us to read?
My lord, under the heading Assessment General Principles.
Yep, thank you. Can I just ask you one other factual question?
Sure.
Please? As it happens, I haven't had to do many cases about length of detention. They used to be very, very
Common.
And in the old days, one was looking at people who were often detained for very many months. What sort of periods are we looking at in ordinary? What's a sort of paradigm case? Somebody who you expect to be able to remove, they're fully documented, or at any rate you have a system for getting the documentation off the relevant embassy. What sort of periods of detention is standard or target? Is that a question that's possible to answer?
Yeah, it's not possible to answer with precision. What I can say in broad.
I don't mean with precision.
No.
I want to.
No, I was going to try and do so. So, for example, foreign national offenders. Yeah. So criminals. It's not uncommon, certainly in my experience, for detention to last up to a year and longer. In cases, there were Somali cases that there were 4 years. In the case of just more general immigration, just removal, especially where someone has been picked up, someone has been detained in order to effect removal, then we're talking about days.
Yes.
Yeah. But obviously there's a if
there's a huge spectrum.
But if the removal direction is then cancelled, then often the view that's taken is, well, that person's resisting removal. Sorry, if he refuses to attend or something, or doesn't comply.
But an ordinary planned detention.
No, I'm just going to turn my back if you don't mind. My lord, if it would assist, we can apparently give you statistics, but what I'm told is the vast majority are sort of short, relatively short.
I still want to know what relatively short means. There has to be enough. There's a minimum you have to be given anyway.
Yes, that's right.
Of course, yeah. But that's less than a week, isn't it?
Right.
So
yeah.
that's a problem.
My lord,
you tend to see a distorted sample.
My lord, it might be simply, if you don't mind, if I just wait, if we get this.
Yeah, well, if over the short adjournment we get some figure, I don't want to be any misunderstanding. I don't want to have lots of contentious detail. I just want to know what in the bog standard case one's looking at. And I've dropped in the back of my mind that we're looking at a period of less than a month. But maybe that. But of course,
I think that would be fair, my lord.
Yes, but
obviously not criminals.
But of course, there will be cases where it goes on for much longer. People who all sorts of things. Yeah. Those are the cases that tend to come to us, and that's why I just want to make sure I wasn't getting a distorted view.
No. I mean,
the recent problem is that there have been very few removals apart from foreign national offenders, and those are the ones who tend to be detained for a very long period of time. Apart from Albania, that's just simply my experience of what's crossed my desk on public law side.
I think perhaps, my lord, the reason those are crossed your desk might be the length of detention, but there are, in terms of just general removal of those who are not present, not lawfully, they are continuing, and they tend to be. They certainly don't tend to run to many months. I mean, I would have thought a month.
Well, let's see what the statistics say, and don't worry. Nobody should worry. We're going to make any great pronouncement about what the figures are, because I'm sure there are all sorts of subtleties. It's just background feel.
Yep.
Yeah. Thank you.
And of course, my lord, in terms of background feel, just to link it there, is that that the second this SOP doesn't apply at all where removal is less than 10 days away. Yep. So if you receive a report where removal directions are set within 10 days, then the decision has to be made immediately. Well, not immediately. It has to be made based on the report. It doesn't go into the SOP process.
I see, yes.
And that's one of the exceptions identified.
Yes, thank you.
Yes. My lords, did you manage to read?
Oh, well, I simply read down to the 2 bullet points.
Oh, my lord, if you could just read over the page up to
right.
who is regarded as an up to that heading.
Yeah.
And you've seen the word serious harm, yeah?
Yes, thank you.
Okay, and then can I ask you to turn to page 213, please? I beg pardon, sorry, I beg pardon. Can I just go, sorry, could you go back to 206, please?
106?
Yeah, sorry, I beg pardon. So that was, my Lord Justice Dingeman, I made a point about conditions, and if you look at the top paragraph, this deals with sort of general physical conditions and evidence. And if you look at this last sentence in the top paragraph, the condition needs to be serious. Otherwise, it doesn't fall within the scope of the policy. And there's a second part, it's all about managing it in detention.
Physical.
Does it say that?
Sorry, what you asked us to read? The whole of page 206?
No, just that paragraph. Apparently, it just relates to physical.
And mental begins at 208, I suppose.
Yeah. Yeah. Okay. And then so 213, please.
Heading at the very bottom, is that it?
Yeah, right at the bottom, my lord, assessing risk, weighing of evidence, and then if you could turn over to 214. And then could you read the first paragraph under level 3, please? And then could you read at the top of 215, there's a paragraph starting...
So again, this confirms that, at least to some extent, the idea of what these levels are effectively determines whether you should accept the evidence.
Yeah.
Though both level 2 and level 3, you should normally accept the evidence.
Yeah.
Yeah. But level 1 is ambiguous as to whether you accept the evidence, but it doesn't matter much, you're giving it limited weight.
Yeah, I mean, if you're interested, my lord, level 1 is dealt with in the bottom paragraph of 214. But in terms of...
Sorry, where are we going now?
Well, I wasn't going to take you to it, but if you're interested in terms of looking at level 1, I mean, it's explained a bit more at the bottom of page 214.
Given the issue is the temporal limit, can I just ask you on the level 3 on page 214? Mm-hmm. And it's about 5 lines down. It says, such evidence should normally be accepted and any detention reviewed in light of the accepted evidence. Mm-hmm. And that does suggest that what the judge found was right, which was that once you had the level 3 evidence, then you review it straight away.
Well, my lord, I I think I'd take issue with the concept of straight away, but I would accept that evidence needs to be considered. But Secretary State's position is that evidence it's not that the MLR isn't being considered; it's being considered by by a medical expert as part of the caseworker's consideration leading to the decision. And if you look at page 215, the top paragraph, you can see that it's specifically stated there that the caseworker can look at other sources. And there's no suggestion as to where those or how those sources are obtained. It's just, or that they can't be obtained if they're not existing evidence or anything like that.
Slightly oddly worded. Caseworkers should not usually disagree with medical evidence. Understand why? There's the strong reasons for doing so. Such matters, these are the sort of strong reasons, may be taken into account in deciding the weight that should be afforded to evidence. Is that just a mealy-mouthed way of saying such matters may lead to you disagreeing with the evidence, which is the phrase used earlier on? Or is there some subtle difference between disagreeing with it and deciding the weight that should be afforded to it?
Oh, do you know, my Lord, I'm not entirely sure. I mean,
no, again, I know we mustn't consider these as a statute, but realistically, that's what we're talking about, disagreeing with it, aren't we?
No, because it could confirm it.
Oh, I see. Oh. Yes, but the whole.
Oh, a big one. Sorry, sorry, I meant in terms of the SOP, but in terms of
this paragraph is concerned with the unusual circumstances which a caseworker can say, I am not accepting what this professional tells me.
Yeah, and this is obviously written before the SOP, the second. This is just a standalone without the SOP
Yes.
process.
Again, this odd word reconsideration. And yet this is all happening at the first stage.
Yeah, all I can say, my Lord, is that it's clumsy wording and
I'm not pleased, and these things are difficult to draft, and they're not drafted by lawyers, and the world would be impossible if they were. But we've got to try and understand what they're really getting at. Yeah.
Then, my Lord, there should be a heading underneath which says external medical reports. And the first paragraph, they're saying these standards apply to MLRs. And the paragraph I wanted you to read was the next paragraph, please.
Starting.
These standards are not intended.
Thank you.
And the point I want to make is that in non-MLR cases, there is no doubt when you read that paragraph that other material can be obtained to make some form of informed assessment of medical evidence. So why wouldn't it be permissible with MLRs? What's the magic about an MLR?
Say it again, sorry.
So when it's when it's other medical evidence, like not an MLR, not written specifically on instructions of a solicitor and related to assess risk, it's just medical evidence.
Yes, I see.
You can obtain evidence, history, treatment, pre-existing. You can obtain that.
Hang on. You can obtain it. It says it could be submitted.
But by implication, there is nothing preventing it being requested in order to make an informed assessment of what the medical records show.
So, you're in Luna House, or maybe he's been taken from Luna House, but he's at reception, or whatever the procedure is in the nearby IRC. And he's having an interview, and the caseworker is deciding whether to continue the detention. And he says, "Oh, well, I'm suffering from a high blood pressure or diabetes or whatever it might be, and it'd be very bad for me to be detained. And it's not an MLR, it seems saying so. And you can say, well, can you ring your GP or get in touch with your GP and produce the material, which obviously takes.
Or we can say, can you give us consent for us obtaining?
Yeah, all right.
Sorry.
But yes, no, I understand that. But and in the meantime, presumably you'll detain them. So it won't take long to get, hopefully. So you say that shows that in a non-MLR case, it's a decision-making process which takes a bit of time.
But I'm saying two things. One, it's the sort of precisely the sort of holistic assessment, which we say the SOP process provides for, certainly in terms of before the final decision is taken, or before a decision is taken. But secondly, in terms of, as you say, time, I mean, you can't tell how long it's going to take, or even if medical consent will be provided necessarily, it provides for a process that isn't immediate, but is a process that can take some time. I mean, if one takes an extreme example and you say there's an MLR that's received or some medical evidence that's received, and the caseworker says, I can't make my decision. I don't really understand this evidence. I can't make my decision on it. Why would it be in any way contrary to the statutory guidance to obtain medical evidence to understand that evidence, the medical evidence you've received?
And as you say, the question in this context is what is being done compatible with the statutory guidance?
Yeah.
And the statutory guidance envisages a self-declaration or evidence such as this, or an MLR. So if it's, you say, well, if you can't inquire any further with an MLR, how can it be that you could inquire any further with a self-declaration or evidence such as this? And you say that would be rather surprising.
And yes, but I go a bit further than that, because obviously you've got the obtaining, even in the level 3 context, things like tribunal decisions. But I think I'm afraid, and I was going to say, but my simple point in terms of the summary guidance is that it doesn't preclude it. Yeah, there's no term in it which says you can't get more evidence, and there's no term in the statutory guidance that says you've got to do this in a de minimis time frame. So when you're looking at it, not in terms of like the general approach, how we've been talking about it, but when you're looking at it, what is the term in the statutory guidance that prevents? Yeah. And we would say there isn't one, and you can't sort of extrapolate what's meant by available in terms of a very legalistic approach in what is general guidance. And leaving that aside, in terms of this de minimis, there is simply no reference to time. So it may well be...
It really feeds into your point you made at the very beginning, that the statutory guidance is not about process at all.
No, exactly. Yeah. But also, my lord, it's very high level. So why would such a high level guidance be telling, be sort of prescriptively defining what you can look at? And the whole point is holistic. So, Marlon, so it's not just holistic. Yep, it's identifying genuine. Yeah, and something which I'm afraid, and I'll just make the submission now but we would say a real feature, with respect to the Linden J, a real feature of his judgment is there seems to be no weight at all attached to the public interest. Because if the Secretary of State is forced to effectively proceed on the basis of what might be a flawed risk of harm, and I'm going to use an exaggerated example, but yeah, for example, in the case of a foreign criminal, when actually waiting 10 days, 5 days, 15 days, to be in a position to make an informed assessment, how is that consistent with the statutory guidance? Which says you need consistent identification of genuine.
And indeed, that doesn't just apply on the face of it to an MLR. It would apply to this sort of evidence.
Yeah.
Such that when you receive the pre-existing report, you have once to make a decision with the presumption in favour of release.
Yeah. But also, you know, my Lord, on the judge's analysis, it doesn't really matter whether there's guidance in terms of the SOP. I mean, really what he's saying is caseworkers cannot, even whatever the case, they cannot, wait for additional information. And rather oddly, he draws a distinction, as you'll see, between, he says you can, for up to a day, if it's an existing appointment, but you can't if you're making an appointment. Now what can you draw from the, how can you infer that from what you've seen at high-level statutory guidance? What is the principal basis for saying you can wait a short time for something that's already in the pipeline, but not something that you arrange in response to assessing, to making the very decision you need to make? Surely, if anything, the latter. Yeah, the latter is preferable.
The model also that we've got to be looking at is that there isn't a once-for-all decision to detain, or once-for-all that's subject to reconsideration down the line. There is a process of taking a decision whether to, I mean, the moment you're not allowed to leave Luna House, you are in law detained. But that initial decision is bound to take some time. In a perfect world, a caseworker may have a complete file and have made up their mind, you know, as soon as someone reports. But it's often not a perfect world. You'll want to ask them, is there anything we should know? I imagine. I think you have some sort of interview when you, even with a planned detention, whether that happens at Luna House itself or on arrival at the IRC. Nobody can have thought you would make a once-for-all decision. And as soon as you accept that, then it's a question of how long is reasonable.
That's exactly it. That is exactly it. But also, my Lord, just using your example, so you pick someone up, take them to detention centre, you say, have you got any medical issues? They say yes. We say, can you provide some medical evidence? He says yes, get the medical evidence. Now, the next stage in that process normally would be make some inquiries as to removal directions. Yeah, because until you know when the person's going to be removed, you can't assess the medical evidence. So you are inevitably involved in a process that involves making inquiries.
I mean, realistically, I'm sorry, I'm banging it, but it's just starting to put it in my head. Although these are described as principles governing whether someone is detained, they're really principles governing whether someone continues to be detained after the initial detention.
To be fair, my Lord, they're both, yeah? And the AAR does make that clear, yeah? So it's both, because if you do have medical evidence available to you prior to detention, yeah, you ought to be making that.
Yes, I see. You don't send the squad round to the house in the first place, or
yes,
you don't
exactly.
detain him when he arrives, or right, yes.
Exactly, exactly.
Well, paragraph 4 of the statutory guidance says the guidance will apply in cases in which an individual is being considered for immigration detention.
Yeah.
So, I mean, it's more a consideration.
Yeah.
Okay, I'm scaling down what I put. In many typical, in some cases, it may be genuinely you don't even knock on the door because of these considerations. But this guidance is intended to cover also situations where there is an initial detention, but you're then considering whether it should be continued.
Absolutely, and it's a guidance which is designed throughout the detention period.
The statutory guidance is throughout the detention period.
Yeah, that's right.
Yeah.
I mean, both, my Lord. I mean, the AAR policy applies throughout the statutory.
Obviously, detention includes continued detention. So and there are procedures built in, aren't there? So many weeks.
Appreciate it. No, but
I'm not sure. We're not really thinking about that. No. We're thinking about the early stage.
No. All
right.
Okay. Well, we would submit. So certainly, in the way that the case is being put, you very rarely get an MLR within a day or two of arrival because the reports take some time. So MLRs tend to be at a longer point further in.
No, I take the point. No, exactly. Thank you.
But also, as I think I've said, when someone is certainly detained in an IRC, they also get to see a medic who can then provide.
Again, there's a huge variety. Foreign criminals may well have been in custody,
right.
and may well have been in touch with their lawyers before their release point, and may well have an MLR at the first moment of immigration detention.
That's right. That's absolutely right.
I mean, just for completeness, I see 298 with the interim guidance. It says the guidance and process only applies to external medical reports contemporaneous with the current period of detention.
Yeah. I mean, to be on, I mean, I'm not sure what that means.
But it's saying if you any report which predates that can be considered on its merits, but it's really focusing presumably on reports.
Yes, yes, my lord. But I mean, my lord, again, without being pernickety, the MLR is all about assessing the impact of detention. So you might well get a report about medical history, or you might get a report about how vulnerable they are. But until they're detained, it's quite unusual to have a report that can actually speak in an informed way about the ongoing impact of detention.
Yes,
I'm not saying you can exclude it, but certainly MLRs tend to be whilst detention's ongoing. Can I also just make one other point, just in terms of this, how the process is supposed to work? If you remember, I've spoken a bit about the SOP, and I've also spoken about the freestanding duty to maintain. And the freestanding duty isn't to every day make an assessment, because that would be unworkable. You have detention reviews over maybe once, I can't remember what it is, but certainly weekly or bi-weekly. So the whole process actually builds into time to consider developments and time to review it. There isn't a process whereby it says, right, you provide something, a decision's got to be made within a day or 2 days or 5 days. It's an ongoing process.
Right. Now, we were on the caseworker guidance.
Yep.
Was there more you wanted to tell us on that?
Just a little, just 218. So it says considering the standards and evidential weight. So if you could read the first paragraph under the heading. So that's again this point I'm making, is that it goes to the healthcare team to consider.
Yes, I'm also just looking at the second one.
Yeah, I was going to ask you to look at that.
How much more then should we read?
Just if you could just read the second paragraph, because I just want to make one point in relation to that.
Yeah.
And so you have the sentence which starts in all cases, and then it says the failure to meet particular standards should be considered alongside, where present, and it's the rest of that sentence which I say is important, because you can see there that that's exactly what caseworkers are the sort of approach the caseworkers are taking under the SOP, because you are looking, and in terms of discretion, you are looking at, make an assessment. You're making that assessment as to what weight to attach.
Does this quite fit the situation where you then get another report which is inconsistent with the first report? The first report seemingly meets the standards. But then you've got another report to put into your thinking.
Well,
is that paragraph cater for that?
Yeah, no, I mean, there are, and I haven't taken to it because it was an issue raised before Mr. Justice Linden, that actually the reconsideration process was unlawful, but Mr. Justice Linden didn't accept that. So in terms of the focus of the appeal, I haven't dealt with that process. But it's actually quite a carefully circumscribed process, because recognising that the caseworker is not a medical expert. So it certainly doesn't provide for difference in opinion. You go for the Home Office one. It certainly doesn't say that.
I see.
So, and then if you, just the last paragraph on the bottom of the page. So, And it's the second bit, so evidence or sources that might impact the liability.
Sorry, which paragraph are we now in?
It says similarly, the last paragraph. And then I've just got 2 more pages to take you to, please. 221, there's a heading evidence assessment. And the as in any case, is, could you read that paragraph, please? So 2 points is to emphasise this is a guide, so it's not prescriptive, it's a guide. And then you can underscore the importance of length of time in detention, because that's critical to assessing, because you can't get an MLR which assesses risk by reference to the time of removal, because they don't know that. And then, my lord, at 222, you've got level 3 again. Perhaps you could just sidebar it. But I would ask you to read paragraphs at 223. The top paragraph, could you please read the top 4 paragraphs? So again, what we say the key factors are the top paragraph shows the holistic assessment. Your public interest is multifaceted. Second paragraph we say is key. It's a guide rather than prescriptive template. And really we say that's where Justice Linden fell in error in terms of applying such a prescriptive approach to something that isn't statute and is guidance. Albeit I appreciate it's not this document he was referring to.
I was going to say.
Yeah.
Right.
So that's it, my lord, in terms of guidance you'll be happy to hear.
225 is Rule 35, so you needn't waste time answering my question. Thank you.
Thank you, my lord. So, my lord, can we now go to the judgment? So, can I take you to, I'm just going to trace through very briefly the submissions and then deal with the 3 paragraphs, which are the key paragraphs. So, paragraph 4, at the bottom of page 84, you have the judge's sort of summary of the policy. Oh, is it?
Mm-hmm. Any particular point you're drawing out?
Well, no, my lord. It was just as a starting point, a big one.
Yes.
And then 6, I would ask you to read, because this is why I was trying to provide context, my lord. If you could just read the way the claimant's case was put. See, so the claimant's case really is that the MLR is being reviewed and the time taken. There's not being suggested any reference to available or anything like that. It's literally, the whole process is inconsistent. Then paragraph 13.
So you're saying that this is the basis on which the judge decided it is not the basis on which it was put?
No, I'm going to take you quite carefully to that point, if you don't mind. But
I just wasn't sure what the point you're making about 6. It looked to me...
You're quite right, my lord. I am going to say that it certainly wasn't the way it was pleaded, in terms of the skeleton arguments or anything. It was put really on the basis that the statutory guidance requires a decision on level 3, and nothing about de minimis, nothing about that, certainly. And certainly not by reference to the word available. Can I ask you to turn to page 86, next page, and the last paragraph 13, and we agree with this, so grounds 1 and 2 require consideration of the text of the statutory guidance and the second opinion policy with a view to deciding whether they are consistent with each other and the purpose of the ground. So we say exactly that. You've got to look at the text. And then the ground 3 is the consultation, which I'll come to separately. Then if you turn to 88, in paragraph 19, this is the first time you get a reference to the detention of the person on the available evidence, if you can see that. And then if you could turn to page 96, please. And look at paragraph 55, sub-bullet points 1 and 2. You can see again the way the claims case is put. So again, and there is no discussion, as you will see in the judgment, as to sort of submissions relating to the meaning of available. And then in terms of the way the Secretary's case was put, on page 98, the last sentence of paragraph 62, the point is made importantly, nor does the statutory guidance prevent the caseworker from seeking further information in fulfilment of the Thameside principles, where it's considered necessary and appropriate to do so in order to make an informed decision. So the points I'm making here were made in the court below. And the point I made in relation to this ongoing duty to consider, that which is freestanding, 65, if you look at read the bottom sentence, consideration is given to the potential vulnerability whilst the second opinion is awaited. So if you could read that sentence and paragraph 66, you effectively have the same point that I'm making to you in all submissions being made by my own friend Ms. Anderson in the court below. And that is, as you've seen, consistent with and reflected in the SOP, which requires the immediate referral of the MLR, and that's at page 299 in the bundle that I've already taken to you. So, against that background, if you turn to 71 to 73, the judge taking the learned judge's reasoning as the paragraphs go. So starting with 70 is basically the general principle about presumption of detention, against detention. 71 says that the guidance, and we're talking about the statutory guidance, recognises these points, and we're not sure what points they are, and require decision makers, and therefore requires decisions about whether presumption against detention have been to be made on the basis of the available evidence. Now, I have already made this point, but that requirement relates to how you take the decision. And then it says, unless the detention is justified on the available evidence, effectively, you can't detain, which is an obvious point, but the question isn't about that. The question is, what are you entitled to, how are you entitled to consider and make that decision? And so the rest of that paragraph relates to this obligation which the judge finds under the statutory guidance to effectively make a decision based on the level of evidence immediately. Because the middle of that paragraph, what he says is, if a person is an adult at risk, the caseworker is therefore required to consider the level of evidence. Yep. And again, I'm going to end up repeating a little bit what I've said, but we say that the caseworker receiving an MLR, providing it on for consideration for a second opinion, and then making a decision, that is precisely a process which provides for that consideration. And there is an acknowledgement to the requirement for regular reviews at the last sentence, which we accept. And indeed, the regular reviews are part of the safeguard during the SOP process. Because if there is some evidence of imminent or real risk, it should be picked up by the healthcare team based on the MLR and any observations. And then 72, it says, the judge says, it would not be consistent with this approach for there to be material delays in acting on the available evidence. Now, with respect, that's just an opinion. That's not tethered to any term in the statutory guidance. And he might be right, but that's not what the statutory guidance says. The available evidence approach means that under the statutory guidance, a person cannot be held in detention where the evidence available to the defendant shows that this is not justified. But that, with respect, sidesteps, doesn't it, the point. How do you decide whether the evidence is justified? It's not paying attention. And what is it in the statutory guidance that prevents you obtaining information to make that decision? It would therefore be contrary to the guidance to postpone consideration of the evidence or a decision about detention. You see, so it's both. And if you look at the latter, for someone who can't make that decision, why? And what is it in the statutory guidance that says, well, you can't wait till you've got the tribunal decision? What is it? You can't wait till the person's given you consent to look at their medical records. Nothing that says that. And then we get to the last point in this point, which is more than a de minimis. And there's nothing in the statutory guidance that says anything about the time. And indeed, the claimant put their case much lower, said it was prompt. You have to take a decision promptly, but it was just done by way of general point, not by reference to a specific provisional term in the statutory guidance. And then 73, if I could just touch on 73, please. The judge says it despite this very sort of prescriptive, so a big one. Could you read this last sentence in 72?
Yeah.
So he says that's pretty prescriptive, but he didn't actually know. Look at and then 73. Doesn't mean that there are no bases on which it might be rejected. That's fine.
Sorry, where are you reading?
Sorry, because 73, the second sentence, it does not mean that the report has to be accepted or given full weight. And this is the important sentence. Nor does it mean that no further inquiries at all may be made. So once you accept that, once you accept that inquiries can be made, then you're all into reasonableness. So it doesn't mean, does it, that the statutory guidance says you can't make inquiries, because he's accepting you can. And then you look at the example, and he says, except that if it was known that the detainee had an appointment the next day, it might be permissible. However, but there's a difference between waiting for a short period of an existing appointment and organising an assessment. Why? And I've made submissions on that distinction, which we say is totally unprincipled. But on any view, that's not what the statutory guidance provides. And then in terms of the point I made about the freestanding, effectively safeguard of the MLR being considered by the healthcare team, I'm not sure the judge entirely focused on this point with respect, because if you look at 74, he says this in the middle. There's a sentence that starts, there's a reference to the caseworker not being required to change the detainee's risk level.
Which sentence is that?
It starts, my lord.
It's the one starting as noted.
Yeah. So that's where it starts, which is fine. I mean, that deals with the SOP. But then there's the next sentence, which starts the characterization in the policy of the position as being that the risk level is undergoing consideration should not distract attention from the substance. And then if you go to 75, he says this, second sentence. So if you just read the first 4 sentences, actually, so I'm not taking it out of context. But the point which I took you to, Ms. Anderson was making, and you saw it in paragraph 76, it's not that this is sort of something to consider by reference to the policy. It's rather separate, ongoing process whereby if the healthcare team looking at the MRR think there's a really imminent risk or there's an vulnerability or whatever, they issue the Rule 35, and a separate assessment is made by reference to the healthcare and the MLR on that process. So it's a safeguard, effectively dealing with imminent risk, whilst the SOP process is being undertaken. So, my lord, those are my submissions in relation to the first ground. I am glad I took a Ryanair approach.
No, thank you very much indeed.
Shall I move on to the consultation?
Yes, please.
Well, given the nature of the challenge to the guidance, I am going to have to, I'm afraid, take you through a bit of evidence. I know that's not something which.
No, I think you're welcome to help on that.
So can I ask you to turn to Ms. Hanley's statement, and that is in the supplemental bundle. And it starts at 72. So it's a very long statement, so just to explain what I'm going to do, and Marlon Frank can obviously point to aspects of this, is I'm just going to focus on a brief description, on the description of the various consultation, alleged sort of engagement or consultation, or whatever you want to refer to it as, and just deal with the opening paragraphs. Yeah. So I'm just going to explain or highlight bits of the process which we submit are inconsistent with it being a consultation, which we say were
very well. I mean,
I'm not going to re-argue.
Speaking for myself, when I was trying to read up on this part, I did find the statement, it was perfectly well written, but it's quite difficult to digest, because you're just given a list, and then we had a discussion about this, and then we had a discussion about that, and then there was this, and there was the other. And of course, the point the judge himself made, it would all be easier to get a feel for it if we'd had the underlying documents, but we haven't. We are where we are, and he in the end made his decision on the basis of what there was. But what I'm rather long-windedly leading up to is that I would be assisted, it may be more for Mr. McCulloch than for you, since he's the one relying on these facts, by some sort of structural summary or presentation of what happened over the evidence so that I can actually get a feel for there were so many discussions in the this or that body and with the other people there, insofar as the evidence shows who they were. But it's not really right to ask you to do that anyway.
Well,
you can't do it on your...
Well,
I'm really just saying that some sort of helpful summary or guide to what Ms. Handley describes over many pages would be useful. I'm not necessarily saying asking you to do it as part of your opening. Your part, what you want to do, is to make your points on what she says.
My Lord, yes, and I would obviously urge you to be cautious in terms of obtaining greater clarity at this stage, because that clarity wasn't available.
I'm not asking for anything that isn't in the evidence. I'm just asking for a more structured way of looking at the evidence we've got.
I agree, my Lord, but one of the points, I'm afraid, which was made was that the quality of the evidence in terms of, it was quite discursive, very long-winded, is that it's actually very difficult to pick out what precisely...
Well, exactly, but that's what advocacy is for. But it's more in Mr. McCulloch's forensic interest to do it than for you.
No, that's okay.
Okay, well, I just thought I'd make that point.
That's right. And my Lord, I might, in fact, perhaps counterintuitively provide you some assistance on that.
The best traditions of the bar and of the government legal service. Yes.
Well, yeah. Okay. Well, that's the first. Okay. 72, my Lord. So, my first point is paragraph 1. The author of the report's been in post since May 2021. This statement is December 2022. So we're talking about someone with direct experience of 18 months. So everything that's referred to prior to that date is based on records, or, as we see it when you get to paragraph 2, it's either review of medical justice organisational records or conversations with other people.
Well, to be fair, in this sort of case, that quite often happens. If it was going to be very contentious, the primary facts, it would be very unsatisfactory. There's no real doubt, although they're difficult to digest, what the primary facts are. The real problem is what conclusions we draw from them.
Absolutely, my Lord. But if it was a Secretary of State who, as you say, often puts in these sort of corporate statements, they are corporate statements designed to exhibit the underlying document.
Yeah,
because without that, the person can't speak about it. And that's my point. Yeah.
But you haven't disagreed in evidence with anything said in this, have you?
Because, we have said that we don't accept the material. That's what our witness says, and we don't accept that we've. I was going to take you to what's said in the judgment, but that's it. We don't accept the material or.
I hadn't understood it to be a ground of appeal that the judge should not have accepted the primary facts recounted by Ms. Handley.
It's weight.
The issue is, once you've established what happened, which is quite difficult, but I hope we're going to have some help about this from you and from Mr. McCulloch, once we've worked out what happened, does that amount to, depending exactly what test you take, a settled practice of consultation, such as to give rise to a legitimate expectation and thus a consultation obligation? So I can see why you can't resist making these sorts of points. But as my Lord says, ultimately, Ms. Handley's evidence as evidence of what happened is not challenged. It's not challenged on the appeal. I know Ms. Anderson tried to say it shouldn't be admitted, but she lost on that, and there's no process, there's no appeal on that point. So,
but perhaps I can put it this way, my Lord, is that the case law is quite clear that, for example, the label attached, the fact that consultation is mentioned or referred to, it's a term of art, and the fact that how it's referred to by a non-lawyer is illegally irrelevant. So here we have a description of, very loose description of things, which is...
It's a problem.
Which is, they refer to as a consultation, whereas it might be, or the fact they're referring to when you look at the underlying material, it's an opportunity to comment.
I know. Well, we'll have to do the best of what there is.
Yeah.
And I mean, although I'm being critical of Ms. Handley's statement, it's a pity that the Secretary of State took the view she did to go for broke and said it should not be admitted. But actually, if a different tactical decision had been taken, we would have had Mr. I've forgotten his name, producing his version and showing us all the documents, as the government would have them too.
Absolutely.
So
but
both sides are to blame, but we are where we are.
My Lord, yes, but we are where we are when it's the claimant who bears the burden.
Yeah, well, that's true as well.
And so if the evidence is unsatisfactory, you may remember from the judgment that, and I'm going to make a more forensic point, but the judge undoubtedly asked quite a lot of questions, or he accepted, I wouldn't say a lot, he asked questions and then decided not to take them into account. And then said, well, if the claimants want to put this evidence in, they can apply to adjourn. And it's slightly counterintuitive here, because if the judge thinks, well, actually the evidence is not clear enough that I need to ask all these questions, sleeps on it, and says, actually, I'll just do it without that. But if the claimant wants to put in evidence that they can apply, then the claimant has had the opportunity to make what is unsatisfactory evidence satisfactory.
But would you accept that it isn't open to you to dispute anything as to the facts that is said by Ms. Hannah?
Yes. So, but subject, I know no one can ever say yes as counsel and then not without a caveat, but it's that, I gave the example, is to whether a fact actually amounts to a consultation.
Yes.
Okay, I think we understand we understand why it's so unsatisfactory. And at the end of the day, you're going to say it was so unsatisfactory the judge should not have made the finding he did on the basis of it.
I might well.
Yeah.
Mark, can I, with that in mind, could I just very quickly take you just to a few key points, please? Page 74. That's paragraph 8, my lord. That just explains what this NASF NASF meetings are. I'm going to take you to one of them. The judge attaches weight to these meetings, and if you could just read first 2 or 3 sentences and then read 9, please.
I actually read the whole thing. There's a whole 8. Yep.
Yep. So, and then
And 9.
Yeah. So really, just so it's clear, the NASF are quarterly, or to be honest, they're often not quarterly, but they're quarterly meetings where, as I'll show you, lots of NGOs attend and lots of things are discussed.
Yes, so again, of course, one would like to see the terms of reference, but we should assume that they are accurately stated. Because
There is actually, no, this is something where there is, it's not exactly on point, but because it's the previous one, but if you look at 123, you will actually get to the terms of reference.
Oh, right. Thank you. I hadn't spotted that.
And then if you look at 124, you see everyone who's invited to attend.
If you look at 1, 2, 3, before we leave it, the third bullet does say provide a forum for consultation, challenge, recognition and arising standards.
Yeah.
Yeah.
Do you want to say anything about that rather than just leave us to read it and try and work it out in our own time?
Well, my lord, that bullet point refers to the what we say this forum is all about, which is an opportunity for holistic discussions about concerns and matters being raised and comments in relation to matters which those who attend feel relevant. And the one I will take you, my lord, there are two records of these meetings, and in one of them, as you'll see, my lord, there's a reference to the fact that a DSO, detention service order, a draft is going to be provided shortly. But we will say I will say when I get there that all that's doing is saying we're going to provide you a draft. We're not committing to doing anything more in terms of which one would normally expect in a consultation process.
All right, but well, you're probably going to make your full submissions when you get to the end. But I mean, the claimant starts at least 15 love, I'd have thought 30 love up, in saying that what this group does is consults on matters related to immigration detention.
Well, we would say not consult in the term of art. We would say.
Well, all right, no, that's why it's 30 love, not not game, set, and match. But this is not an informal document.
No, my lord, but it is a document that sets up a general forum for discussion about a huge range of matters.
Well, you're saying discussion. It says consultation.
Well, I think, my lord, it says facilitate discussions above, facilitate the development.
Yes, I understand that, but also C, provide a forum for consultation.
Absolutely. So it's a forum for.
I see. So you say that when we choose to consult, this is the forum in which we will do it. Yeah. Okay.
Well, Manuel, I think I'd go slightly further, which is that the word consultation here isn't being used as a term of art. It is being used in conjunction with the other words in that sentence, which is really, as you'll see, it's just, when you look at it, it's a general discussion where everyone raises concerns and issues that need to be clarified and matters that should be considered. And it does touch on policies sometimes. But it's not a formal process whereby, as the judge found, every AAR adults at risk policy, there's a sort of some assurance that that will be considered during those reviews.
Yeah. Okay.
Okay, so that's.
Can you highlight the next bullet point?
Sure. Which one? The whole page. Yeah?
No, just the next bullet point down.
Don't worry, we've read it.
Yeah. Can you read all the bullet points at 123, please?
The fourth one, yes.
Okay. So can I ask you to to go back to 78, please? And paragraph 17, and there's a sentence that says, for over 15 years, medical justice has sought to constructively and proactively engage with the Home Office in discussions about relevant detention laws and policies. That's accepted, obviously, engagement.
Sorry for over. Yes, I see. Thank you.
Yeah, so it's the fact that medical justice seek to proactively engage, that's different, though, from consultation. The next sentence is, we've been consistently involved to respond in consultations on a range of policies. Well, the Home Office evidence accepts that there are policies in relation to which there have been consultation. And
Okay. Yes.
But the evidence in here when you only starts at 2016, so there is no evidence about the preceding years. Although it's a reference to 15 years, you have no idea what in fact is being relied on pre-2016. And you have no idea what type of matters were being, or policies were being consulted on.
You said the evidence only relates, you mean the detailed evidence that she goes on to give?
Yeah, I mean, the first one is page 80, and it's June 2016. So there might be something slightly preceding that, but 15 years, which is what the judge relies on, there is in fact no evidence really as to what happened before 2016. So when you're looking at, is there an unequivocal sort of promise and commitment, that's an important consideration. And then,
well, the period doesn't matter so much as depending on the density. If there'd only ever been one consultation during that period, claimant would be dead in the water, but she's saying there'll be lots.
Yeah, but if you're saying there's a pattern spread over 15 years and you have no evidence in relation to half that period, then that's a finding which we would say isn't based on fact. It's based on an assertion, but no evidence. Okay. Can I ask you to by someone who wasn't in post? Paragraph 18, and there's a reference to concerns about consultation, but those concerns are equally consistent with what's being described as not in fact being consultations. Because if you're sent an email and asked to reply in a few weeks without giving enough information, that might be contrary to the gunning principles. But if in fact all that's happening is views are being sought, then it's for that reason that the gunning principles don't apply. And then 19, at the bottom it says, Home Office does routinely and consistently consult and seek views from caseworkers. So again, it's an assertion, and it effectively elides consult and seek views. And then at 79, 4 lines from the top, it says, often the consultation is done through the detention subgroup, given its terms of reference, but sometimes it's done through emails. And then it says, sometimes the Home Office describes the invitation for stakeholder feedback as engagement or an opportunity to provide comments rather than consultation. Okay, and in the examples that are given, that sort of distinction as to when this would happen or that sort of essential detail is not provided by reference to the examples. And then 20 says that having looked at the material, which we don't know what material they've looked at, they say that they haven't been able to identify a key policy development. So what is that? What is a key policy development? That's not defined.
No, but you haven't provided any example where it isn't true.
That's absolutely right, my lord. But still, it's the claimant's case that this type of policy, this SOP, there's a legitimate expectation for that to be consulted on. So you need to, with respect, we would say, identify with some precision, given that it's unequivocal evidence of consultation in relation to that type of a change, an operational. So not perhaps I'll make this point now. When we go through the examples, you will see that the guidance, that what's consulted on, according to the claimants, and we would say what's engaged on, but leaving the terminology aside, are DSOs, so detention service orders, regulations, and statutory guidance. There may be one example of an operational guidance, and this is an operational guidance, the SOP. It's not a statutory guidance. So that is why it is important, if you're going to say, you, the Secretary, you've promised to do something in the future, that you identify, that it's clearly identify what is meant by key policy development.
Well, I think perhaps it'd be something for after the adjournment.
Oh, sorry.
I need help for, or what's the distinction between operational guidance and the DSOs, for example. These are all things which, in practice, govern how caseworkers decide cases. They can be judicially reviewed if they don't follow the guidance without good reason. Guidance is published to the world as how they are expected to do it. And I don't particularly see what the significance is. Now, you will be able to answer that at 2 o'clock.
I would do my best.
If you really want to answer it now, and we'll do it within 1 minute, you can do it now.
I can say in a nutshell, it's the formality of the change that's being made. So when you're looking at, the need to, or the obligation to consult, obviously if you're going to make a major change to regulations, or you're going to change statutory guidance, or you're going to actually issue a DSO, those are, we would say, key, arguably key, if that's what's being defined as key. What we're talking about here is an operational guidance change, and operational guidance changes don't have that formality. And they are made all the time.
Is there evidence about that?
Well, you can see the number of versions, that are, and in fact, in this statement, they refer to, although they say they're always, medical justice is always consulted prior to things, it's accepted that there are 3 or 4 of these examples that they were changes subsequent, which they weren't consulted on because they are.
Okay.
My Lord, thank you very much for your patience. I will do my best to wrap it up in half an hour.
Yes, I mean, if you have taken a long time this morning, it's just we asked to be taken through it in detail, so don't feel any abashed about that. If we do have to go into tomorrow, we do, but let's see how it goes.
Thank you, my Lord.
Alan, you're going to do the academic point at some point.
I did think I'd be a bit quicker. I'm sorry.
No, you've had some
That's why I said
intervention.
That's why I did on so because you must have had the same experience.
Yeah, very familiar.
Especially on immigration. Go out.